So good afternoon and welcome at our lunch break discussion on the developments in Italy in the field of platform work. I am Cecilia Lazzaroni. I am project officer at the ETUC, where I work with the team on non-standard work and platform work. This lunch break discussion is one in a series. We had one already a couple of weeks ago focusing on Spain and the lay rider, a recently approved law for food delivery riders. And we have already another meeting scheduled for 8 June, where we will discuss with our colleagues from Switzerland. But today we're going to talk about recent developments in Italy. There have been several over the past months. And we have the pleasure of having here with us to talk about these developments Francesca Baiocchi from UIL Trasporti, Gianluca Bianco from CISL, and Massimo Mensi from CGIL. During this debate that is streamed on Facebook and Twitter, you can send us comments and like and share. We will make sure that we answer any questions that the questions that we may receive. Before jumping in discussions, I would now like to give the floor to our Confederal Secretary, Ludovic Wood, who will give us a political framework for this debate. Ludovic.
Yeah, thank you, Cecilia. I'm happy to be here to discuss with you the Italian case and the recent development in platform work. I think it's important for us to have this discussion on the development at national debates because we are following closely the topic at European level with it is in the European agenda for this year. So what we can say, 14 months after the start of the confinement due to the COVID-19 epidemic, workers active on the platforms are still denied almost all of their social and collective rights. Recent court cases and administrative decisions and also a governmental decision, as in the case of Spain, but we know also that in Italy, in Switzerland, in Belgium, in France, in the Netherlands, and in the UK, there have been recent developments that have shown that the platforms are still in breach of the respect of workers' rights and recognize these court cases and administrative decision, recognize again and again the misclassification of workers as bogus self-employed, while the platforms behave with the help of the algorithm management tool as an employer. It is then high time to turn these legal advances in political transformation, and this is what we want to do with the European Trade Union Confederation at European level. While these judgments create important legal precedent, they only deliver justice for individuals and small groups of workers and leave companies at liberty to continue exploiting millions more. So it's important, of course, development with court cases, but then trade unions have to transform them in concrete victories for workers. And this is also what we will discuss today with our Italian colleagues. But we cannot wait that every platform urgently need that the European Commission brings an initiative that will finally put an end in every member state to the abuse of workers by platforms through forced self-employment. Today we will discuss about Italy, and we will continue this discussion on other countries further in the following months. Thank you for being with us.
Thank you, Ludovic. So in your introduction, you talked about the misclassification of platform workers and more particularly food delivery riders. We know that in February this year, the court in Milan concluded that food delivery riders for a series of platforms operating in Italy are not independent self-employed, but that they have a relationship with platforms that is of hetero-organized collaboration. On this, I would like to ask Francesca if she can give us a quick overview of the case that the Court of Milan carried out and include the most relevant elements that emerged with this case. Francesca.
To start saying that the inquiry started it was launched in 2019 and it came after a series of road accidents that happened to riders. So the labor office started to wanted to understand if those workers were falling under the provisions of health and safety law. But to establish that, they had to understand if they were employed or self-employed. So they started doing an inquiry, they were doing road checks to those workers, asking them some specific questions to try to understand which kind of relation there was between them and the company. So what it emerged from all this work that wasn't done only in Milano, it started in Milano, but then it was extended all over Italy, and it concerned the delivery companies that were involved in this research. It was Glovo, Uber Eats, Just Eat, and Deliveroo. The result of all this inquiry, it was that those workers have been misclassified. They were not self-employed, but there was a strict relation between the company and the worker. Because the work was organized, it's organized by the company, they are part of the company organization, they are part of the business model of the company. The company wouldn't exist without them. They are related to the company, they work through time bands, but those time bands are very strict and they have to follow them, otherwise, because they get into a ranking and a performance indicator, and if they don't respect them, they will be gradually kept out and they will not be hired anymore, let's say. At the end of all this inquiry, to make it very, very simple, the results were that the public prosecutor and the Italian labor inspector stated that those workers have to be reclassified, and the law on health and safety has to be applied to them. So it means that the company has to make a risk assessment, has to make a checkup evaluation of the workers, has to address the workers on prevention, has to provide the workers for the PPE, and then has also to pay social security contribution that has been missed since now. And they even quantified a fine that it's more than 700 billion euros. And this is the state, and this is a very, very recent ruling that is very important, because it's an important guideline, it's an orientation that defines the status of the workers that is not self-employed, for sure.
Thank you, Francesca. If I remember correctly, food delivery platforms had 90 days to comply with the indications by the court. Are you aware if they have taken steps to comply?
We had rumors, let's say, that they are doing some legal recourse. But the 90 days, if I'm not wrong, haven't technically passed. Okay. They will be around the end of May.
Okay, thank you. But this inquiry took place and just before negotiations started, or more or less in a convenient time frame compared to negotiations with Just Eat. We know that Italian trade unions concluded an agreement with Just Eat. Did the inquiry from the Court of Milan have an impact on this agreement?
Cecilia, honestly speaking, we have to say that Just Eat had a different attitude. And there were already meetings going on between the parties. But for sure, we can also state that the inquiry from Milan, let's say, accelerate the process.
Thank you. Thank you, Francesca. I would like to ask about this agreement that Italian trade unions signed with Just Eat, and for this I would go to Gianluca. So Gianluca will speak Italian, but I will translate, I will be his interpreter and I will ask questions. So Gianluca, if you could please briefly illustrate the main points of the agreement between the Italian trade unions and Just Eat. I punti principali dell'accordo quindi tra Just Eat e i sindacati italiani. Prego.
Buongiorno a tutti e grazie per l'invito, è un piacere essere con voi. L'accordo Just Eat parte da una scelta aziendale di modificare il proprio modello organizzativo a livello mondiale e di avviare alcune sperimentazioni in alcuni paesi dell'Unione Europea, tra cui l'Italia. Il sindacato italiano da tempo chiedeva alle imprese del food delivery in Italia di cambiare organizzativo, cioè di abbandonare l'unico modello basato sul lavoro autonomo occasionale. È chiaro che per noi è stata una svolta importante questa, è un'esperienza che abbiamo tentato di praticare con la contrattazione.
Good afternoon, everyone. It's a pleasure to be here. The agreement with Just Eat was a choice that answered the willingness of the platform, the intention of the platform to revise its organizational model worldwide. This reorganization started in a selected number of countries, including Italy. And it answered to demands by the Italian trade unions, demands that that Italian trade unions had been already putting on the table for quite a long time. These demands concerned abandoning the only model that had been adopted so far of an autonomous status for food delivery workers. And this agreement is an important and welcome development. So thank you, Gianluca, for this first reply. We imagine that negotiations must have encountered, were there any critical points during negotiations? And if you encountered any criticalities, how were you able to solve them? Gianluca, se puoi raccontarci brevemente delle negoziazioni e eventuali punti critici.
I punti critici sono stati dovuti proprio alla complessità della questione. Infatti gli accordi sono due che abbiamo fatto, un accordo interconfederale quadro che ha riconosciuto come modello organizzativo appunto il lavoro subordinato e il riconoscimento del contratto collettivo nazionale del lavoro, della logistica e trasporti. E il terzo punto, la necessità di un accordo specifico fatto appunto dalle categorie dei trasporti, della logistica e dei lavoratori atipici, un accordo di secondo livello, un accordo aziendale che di fatto è andato ad adattare il contratto nazionale di lavoro della logistica alle specificità del modello organizzativo Just Eat. Sia per quello che riguarda appunto le tipologie di rapporto di lavoro, si potrà usare il lavoro intermittente, a termine, a somministrazione. Il modello organizzativo è basato sul part-time breve, 10, 20, 30 ore settimanali e anche però un riconoscimento di una retribuzione oraria come previsto dal contratto nazionale di lavoro, che sarà maggiorata anche da una parte variabile legata alle consegne che i ciclofattorini faranno.
So any difficulties met in negotiations in the negotiations of this agreement were tied to its very complex nature. This complexity was the reason why two separate agreements were necessary. One was a framework agreement that includes details concerning the subordinate nature of riders' work and an adaptation of the national contract on logistics. The second agreement concerned the more specific nature of non-standard and the more specific nature of this sector and dealt with the aspects of non-standard work and the transport aspect. This second agreement is at company level, so has been obtained by adapting the national contract on logistics, and it includes a series of important elements. For example, details on the type of work relationship that intercourse between riders and the platform, and several possible agreements that can be of short part-time works or intermittent contract, etc. And this includes also points on the hourly engagement by riders and also on the remuneration. Gianluca, if I may ask you one further question, what would you say are the main takeaway points, the main results of this agreement with Just Eat?
I lavoratori avranno una retribuzione oraria che sarà composta da una parte fissa e da una parte variabile. Quindi abbiamo superato l'idea che in Italia viene chiamato lavoro a cottimo, cioè solamente retribuito a consegna. Questo è un dato estremamente importante. Sicuramente vengono riconosciute tutta una serie di tutele e diritti contrattuali sia sul piano normativo sia sul piano economico che sono riconosciuti ai lavoratori subordinati. Quindi è un passo in avanti notevole, soprattutto perché ottenuto grazie alla contrattazione, e quindi noi reputiamo sia questo un'esperienza importante da valutare. È un accordo che ha una base sperimentale, però lo stiamo monitorando e siamo sicuri che possa essere una buona esperienza da praticare anche nel settore. Probabilmente non in tutte le imprese, ma è sicuramente un'esperienza importante, una buona pratica da portare appunto nel panorama nazionale e ci auguriamo anche in quello internazionale.
Thank you, Gianluca. So the main points of the agreement, the main takeaway points are that it allows workers, it gives workers the right to an hourly retribution that is composed of a fixed part and of an hourly rate. And this goes beyond the model that has been adopted so far, that was an ancient model based on each single delivery. It also includes basic important rights and protections, including legal and economic rights for the riders. It is a definite step forward, also because it was achieved through collective bargaining. It has a pilot nature, so it's the first of its kind, but unions are confident that it's going to prove useful also for other cases and are monitoring it. Thank you very much, Gianluca. I want now to ask Ludovic, now that we are halfway through our conversation, if you have any points or any remarks that you would like to share with us.
Yeah, thank you, Cecilia, and thank you, colleagues. I think that the cases and here what is explained with the agreement with Just Eat shows that unions are doing the job. Unions are trying their best to really defend the workers, to engage in negotiations with platforms. And when the platforms recognize herself as a company and as employer, it is possible to bring good results. But what we see Europe-wide, worldwide, is that platforms pretend that they act as intermediaries, that they are not the employers. And that is exactly what we will need to ensure in the European initiative that will come, is that, a digital platform company is just as a regular business an employer and are not digital intermediaries. And with this, I think the case of Just Eat is really important because the link that you did in Italy, that Just Eat has to be linked with the collective agreements in the logistics sector, is exactly what we need also to ensure that the platformization of the economy is compatible with labor and social rights. It's not only in platforms. We need, of course, that platforms in food delivery are linked to either food collective agreement or logistic or transport collective agreement, depending on the countries. But we also need that in new jobs that will come through platforms, like we see with cleaners, like we see also in a lot of other professions, that it's possible that platforms will develop themselves in these sectors. We have to ensure that they are linked to the conditions that workers have bargained through traditional companies. So this is, I think, the main takeaway, I would say, from what you said for me, is that we really have to of course, reclassify them as workers, but it is impossible without speaking about the one we have to tango with, the employer. If we have to recognize that they are employers, that they are linked to a sector of activity, and that this is the conditions of this sector of activity that they have to respect.
Thank you, Ludovic. And still talking about agreements, in September 2020, we were reached by the news of an agreement signed between Assodelivery, that is the Italian Association of Employers in the sector, so of platforms, and which includes platforms, and UGL. There are now doubts concerning the legality of this agreement, and I would like to go back to Francesca to hear more about these doubts and concerns. Francesca.
Aspects that we would like to highlight about the contract signed by UGL and Assodelivery. First of all, we're talking only about one union, where the three Italian major confederations that represent most of the workers in all sectors have been kept out. So just from this only few indications you can understand what we are talking about. It's an agreement that lays down in only, I think, more than 30 something articles. It always stresses the fact that they are self-employed and that they are completely in a different, following a different path of the one of the confederation, because what we are doing is it's the Just Eat contract, not those different things, the third ways. And even because it lays, because we consider it, and there are some elements, work to peace. And we would like to remember that for the Italian legislation, this is banned in Italy. And that another legal aspect is that a CBA that's signed only by one union, that hasn't got the majority at national level, cannot derogate from law provisions.
Thank you, Francesca. So we understand that there are serious concerns regarding both the representativity of this agreement and its quality. But are unions trying to negotiate with Assodelivery? Gianluca.
Sì, noi stiamo avendo anche un confronto più generale con l'associazione che raggruppa le più grandi imprese del food delivery nel nostro paese. Da questo punto di vista, quindi anche qui, attraverso la strada della contrattazione, stiamo cercando di portare a casa dei risultati che abbiano una valenza estesa a tutto il settore del food delivery. Abbiamo fatto un protocollo sperimentale sulla legalità il 24 marzo contro l'intermediazione illecita e lo sfruttamento lavorativo nel settore, un accordo che abbiamo sottoscritto tra le parti sociali, ma poi sostenuto anche dal governo, dal Ministero del Lavoro. Abbiamo un tavolo aperto sulla salute e sicurezza sul lavoro e dovremo avviare anche un terzo tavolo sulle tutele più complessive per i lavoratori del settore. Quindi in Italia molto si sta facendo nelle aule dei tribunali, la legge si è mossa, però diciamo che la strada privilegiata che noi stiamo cercando di perseguire è proprio quella della contrattazione. Ci auguriamo che questa porti anche a breve a ulteriori accordi per tutelare al meglio i lavoratori del settore.
Thank you, Gianluca. So yes, Italian trade unions are indeed trying to achieve a more general agreement with Assodelivery, and this through the path of collective bargaining. This agreement should allow to achieve results that apply to the entire sector. One first step was a pilot protocol that was signed on 24th March, which concerns the illegal exploitment of workers. This agreement was first concluded by the social partners, but it was then also subscribed by the government in the person of the Ministry of Labour. There are other open tables for negotiations concerning health and safety, but also more general protections for workers. These will definitely be very important developments because so far Italy has made very important steps forwards through legal action in quotes, but achievements made through collective bargaining are needed. Thank you very much, Gianluca. Gianluca mentioned the fact that Italy has tried the way successfully of taking platforms to court. I would now like to discuss briefly one of the several cases that have taken place recently. We remember there was a recent court case in Palermo. We know that the Court of Milan led an inquiry on gang mastering, but we also know that there was a very important case in Bologna on the transparency of the algorithm. Elisa Gigliarelli had planned to be here today with us. She is involved in negotiations, but fortunately Massimo Mensi is here to talk to us about the Bologna court case. So Massimo, if you could briefly tell us what are the main points of this decision of the Court of Bologna. The floor is yours.
Thank you, Cecilia. Well, the Bologna case is about Frank. Frank is not a person, is not a man, but is the name of the algorithm developed by Deliveroo that was the object of a litigation promoted by the CGIL federations in Bologna. If we should summarize the litigation, we should adopt a claim like something like this. Frank is not blind, but he could see very well when he punishes the workers on strike. The Court of Bologna accepted the claim for a collective discrimination promoted jointly by NIDIL, PhilCAMS, and FILT, the three CGIL federations involved in the food delivery policies. For the very first time in Europe, a court recognized that an algorithm is not neutral in its decision, but is consciously capable of discriminating because it reproduces in a never-ending way the logic and the bias of its programmers. According to the court, the complex mechanism related to the work shift booking, which favors access to work opportunities on the basis of a reputational ranking adopted by Deliveroo concretely hinders their participation to the trade union activities. And not only. The Deliveroo organizational model based on digital reputation privilege the riders who offers a completely availability to guarantee booking time slots and vice versa penalize by slowly outstanding him or her from the daily activities, the one who does not ensure the same availability to join union strike or even for health reason or to assist a family member. The court found that the evaluation model adopted by the food delivery platform took its origin from a conscious choice by the company, not to considering the cause for not logging in to the platform. It's the algorithm blindness and insensitivities to the various reasons that makes it discriminatory. It's very meaningful that the court, the judge, humanizing the program, states that when it wants, Frank, the algorithm, the platform can take off the blindfold that makes it blind or unconscious of the reason for the rider's absence to work. And if it doesn't, it's because it has deliberately chosen to do so. The court also recognized the right not to be discriminating and the discriminatory nature of this algorithm.
Thank you, Massimo. So we may say that Deliveroo's algorithm, Frank, is blind only when Deliveroo wants it to be blind.
Yep.
You said that this was one of the first time in Europe that the algorithm was found to be discriminatory. Are there other reasons? The decision was welcomed at the same time all over Europe as a landmark decision. Why would you say it is so important?
Well, it's important because it's the very first complaint in Europe. Indeed, it's the first time that a legal action of this kind has been brought, and it's the first application of a national law, the law number 128 of 2019, which intervenes in particular in favor of certain categories such as the riders. And in examining the sentence, we will have the opportunity to learn how the algorithm worked so that we can offer an early socialization and a useful precedent for all the trade unions. And it's important also because reputational ranking doesn't not seem to meet the expectation of transparency, as Deliveroo said, and turn out to be a form of disciplinary power. The reputational ranking is the core of the platform labor system, and the Court of Bologna sanctioned it as discriminatory.
Thanks. You mentioned transparency. I imagine that you might have met several difficulties in proving that the algorithm was discriminatory, exactly given the issues with transparency. How did you manage to secure this win while you were dealing with such an untransparent issue as the algorithm?
Well, the analytical description of the platform was only possible thanks to the careful observations and discussions with the riders' delegates who revealed the functioning of the platforms whose structure, logic, and even the language present completely new aspects that are alien to the traditional case law in our courts. I think that the key words is organizing, as we did, for example, with other kind of platform in Amazon with the whole supply chain. So the keyword, it's really, especially in this case, unionizing.
Thank you. And this would open another entire discussion, organizing platform workers, but I think that it is now time to go back to Ludovic for the conclusions. Thank you so much.
Yeah, thank you, Cecilia, and thank you to Gianluca, to Massimo, and Francesca. I think this shows how important it is now also to transform all this work at European level with the European initiative that should come at the end of the year. I would summarize our demand here with the ETUC from the starting point that, as I said in the discussion, we cannot just wait that every single platform, every single platform in every city, in every country complies with the rules that they have to apply. We need to enforce this. We need to enforce this with clearly an advancement in the rights of the workers that are occupied by these platforms, but also in a way that we frame the digitalization of the economy compliant also with social and labor rights. We have seen that national courts find that platform companies are flouting the rights of workers to proper pay and working conditions. It is something that is relevant everywhere in Europe. And for this, we think that with the ETUC, in the following initiative at European level, we will need two important elements. First one is that we need to go to a presumption of employment status for the workers occupied by a platform, and that this presumption of employment status should be complemented by a reversal of the burden of the proof by the platform themselves. So they have to prove that this is not the case. We think this is the only way not to have the misclassification that we have for the moment, the only way to really protect workers. This means also that we oppose in this discussion the creation of a first status. So there's often lobbying that is done by platform to say that there should be a status in between employees and self-employed. We clearly oppose this because we think it would be the worst option for workers because they would not have the autonomy of the self-employed. They would not have the security of the workers. And we know from the court cases, from the work that is done all over Europe, that in fact there is a misclassification and that it is also possible to achieve agreements with platforms to have collective agreement with platforms that ensure that workers can have hourly wages, have health and safety risk protection, all the algorithm that has also to be discussed and to be transparent. I think it was mentioned today how discriminatory the algorithm can be. So it has also to be at the center of the discussion with trade union representative and workers representative, how companies and how platform companies invest in algorithm and how they would behave, so to ensure that there's no discrimination. These are the key elements that we have to do, and as I said also before, for this, we need to recognize that these platforms are employers, that they are companies with obligations, with the function of employers, and this is the only way to link them also to the sectors of activity where they are. So to ensure also a level playing field, to ensure that in the future they would not replace traditional employers in the sectors, the traditional employers that comply with the rules. So thank you for this. I think this was an interesting discussion. I want also to thank all our colleagues working in this field on the ground with here our Italian colleagues, but also we had the occasion to discuss with our Spanish colleague. It is also the efforts that all our unions are doing at national level that shows the problem that reach really solutions for workers and show how relevant unions are in the 21st century and how relevant trade unions are and will be in the platform economy to ensure that is the only way to ensure that workers are respected and have full respect of their labor and social rights. Thank you. We will have in 2 weeks another discussion with our Swiss colleagues, because in Switzerland last year there was also a decision to oblige a platform to have workers as employees. And they are often, these platforms are often saying that they can't comply with the rule, that it's impossible for their business model to do it. We know that it's not the case, because just in the case, the Italian case, our colleagues have shown how Just Eat is doing it. We know from our Nordic colleagues that there are also other platforms complying with the employment relationship and the employment status, but you will also know from the Swiss cases that it is also possible to have an employment status for workers in the platform economy. Thank you. See you soon.
Thank you. Bye.